The 1984 court erred in another way as well, in the distinction between implicit and explicit delegation of powers. Chevron cannot be reconciled with the APA by presuming that statutory ambiguities are implicit delegations to the agency. That presumption does not approximate reality. A statutory ambiguity does not necessarily reflect a congressional intent that an agency, as opposed to a court, resolve the resulting interpretive question. Many, or perhaps most, statutory ambiguities may be unintentional. And when courts confront statutory ambiguities in cases that do not involve agency interpretation or delegation of authority, they are not somehow relieved of their obligation to independently interpret statute. Instead of declaring a particular party's reading permissible in such a case, courts use every tool at their disposal to determine the best reading of the statute and resolve the ambiguity. But in an agency case, as in any other, there is a best reading all the same. The reading the courts would have reached if no agency were involved. It therefore makes no sense to speak of permissible interpretation that is not the one the court, after applying all relevant interpretive tools, concludes is best. The Constitution uses explicit, not implicit, delegation of powers, as seen in the 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. That leaves no room for anyone to exercise implicit powers. They must be explicitly delegated. Furthermore, the power to write laws is vested solely in Congress. From Article 1, Section 1, all legislative power herein granted shall be vested in a Congress of the United States, which means executive agencies have no power, implicit or explicit, to make, modify, or interpret laws to their own understanding. For that matter, neither do courts have the power to make or modify laws, only to interpret what is written. The 1984 court assumed that those making the decisions in the agencies would have special competency in their area of expertise, an assumption that has been shown to be flawed. However, today's court recognizes that those agencies do not have any competency in dealing with legal ambiguities. Perhaps most fundamentally, Chevron's presumption is misguided because agencies have no special competency in resolving statutory ambiguities. Courts do. The framers anticipated that courts would often confront statutory ambiguities and expected that courts would resolve them by exercising independent legal judgment. Chevron gravely erred in concluding that the inquiry is fundamentally different just because an administrative interpretation is in play. The very point of the traditional tools of statutory construction is to resolve statutory ambiguities. That is no less true when the ambiguity is about the scope of an agency's own power, perhaps the occasion on which the abdication in favor of the agency is least appropriate. The court then pointed out that political actors are not suited to interpreting laws. Finally, the view that interpretation of ambiguous statutory provisions amounts to policymaking suited for political actors rather than courts is especially mistaken because it rests on a profound misconception of the judicial role. Resolution of statutory ambiguities involve legal interpretations, and that task does not become policymaking just because a court has an agency to fall back on. Courts interpret statutes, no matter the context, based on the traditional tools of statutory construction, not individual policy preferences. To stay out of discretionary policymaking left to the political branches, judges need only to fulfill their obligations under the APA to independently identify and respect such delegations of authority, police the outer statutory boundaries of those delegations, and ensure that the agencies exercise their discretion consistent with the APA. By forcing courts to instead pretend that ambiguities are necessarily delegations, Chevron prevents judges from judging.